Welcome to Harbor Rock Wealth Management's Planning Tip of the Week. My name is Ruben Smith. August, as you may know, is or may not know, is National Make a Will Month. And in light of that, I thought I would discuss today the difference between wills versus trusts. Now, when I speak of trust, it's going to be speaking about specifically revocable trusts or living trusts and the differences between the two. When it comes to a will, the importance of a will is that you're able to name specifically executors of your estate. So upon your passing, who will settle your estate or be the administrator of your estate. Also, if you have minor children, which I do, it's important to name legal guardians over your minor children. If you happen to pass away with debts, whether it's a mortgage, credit cards, you name it, you will be allowed to go in and determine within the will determine and dictate how those debts are paid off. Now, wills do tend to be fairly easy to establish. You can go online and do a Google search and find a template for a will, especially if you're one that would hold up as far as language within the specific state that you reside. And for that reason, they can be relatively low cost too to administer or to establish. Now, you do have the option of also going through your estate attorney or legal counsel to establish that as well, but it would more than likely come at a higher cost. Some downsides to having just a will is that there's a good chance your overall estate would still be subject to probate. So wills do not help you avoid probate. They also become once your estate goes through probate, it becomes a public record. Okay, so from privacy and confidentiality standpoints, most of our clients would prefer to not have their financial affairs and how their estate's distributed held as a public record. Now, when it comes to trusts, and again, specifically revocable trusts, this becomes more of a bulletproof option from an estate planning standpoint. And the reason being is it helps you avoid probate. And whatever the wording is in your trust upon your passing, that becomes final. It typically is held up in court. So if anyone challenges it, that would help offer protection against that as well. And it could also help you avoid conservatorship, because inside of the trust you would designate what's called a successor trustee. And that essentially, upon your passing, their trustee privileges become exercised. So the trust is finalized, and now, because you have named a successor trustee, they become the primary trustee and decision maker over settling the trust and the estate assets. Now, as you can imagine, a trust is a little bit more involved. It's more detailed as far as your specific wishes and desires as how your assets and specific assets are distributed, also in the manner as to how they can be distributed. So you have a lot of control and flexibility. But because it's more involved and there's a lot of one-on-one typically with your estate attorney, it can be more costly to not only establish but maintain down the road. So if you want to make adjustments and tweaks to your revocable trust over time, that could come at a cost as well. From a privacy standpoint, this is completely confidential. So it is not a public record if you're settling your financial affairs or your estate if everything has passed through the trust. Now, there's a couple of things that both a will and a trust provide. And you can always, in either one, as long as it's a revocable trust, you can always change the name of your beneficiaries or the organizations perhaps that you're distributing some assets to upon your passing. Excuse me. It also allows for revisions. So if at any time you want to make changes to the wording or maybe a power of attorney or medical directives, you can make tweaks to either one of them, whether it's in a will or a trust, at any time. And then they both also allow you to leave assets to minors specifically. Now, be very careful with that, because you want to make sure that you either have guardians in place or you have the right administrators in place to be able to manage those assets appropriately while your children are still minors. With all that being said, it would be my preference that each client go through a proper estate planning exercise with an attorney. And the reason being is that when you work directly with an attorney, everything that we talked about, whether it was a will or a trust, all of that is encompassed into that exercise. So you would have a will established, and again, that determines guardianship for any minor children, who's your executor, how your debts are paid, um, any of those miscellaneous or residual personal belongings that you want to go to specific family members or heirs. That's where that would be cleaned up. And they would also establish a trust, and they would counsel you on that as far as the wording and getting that established. And then above and beyond that, there's also the power of attorneys. So who's going to be able to make financial decisions for you in the event you're incapacitated or you can't make those financial decisions? And then the last component would be medical directives. Let's say you're ill and you're, again, incapacitated. Who's going to be able to have access to your medical records and make those important medical decisions on your behalf? So that would be my preference for every client to go through a full estate planning exercise. Now, there are some clients that can get away with just having a will, depending on their overall financial positioning. But I think going through that exercise, it encompasses so much more. And at the end of the exercise, I know it's not the easiest topic to discuss. Your clients do feel a little bit better as far as where they stand, knowing that if something happens to them, everything's taken care of, and their and their estate will be settled as they want. So I hope you enjoyed this and got something out of it. If you have any questions or would like to take a deeper dive on either of these, a will or a trust or the estate planning process, please don't hesitate to reach out, and we'll see you next week. Thank you.